150-year-old law that's already been on the books. It's not a new effort of Congress to intrude into the electoral process. It's merely intended to clarify a law which virtually everyone that's discussed it over the past 25 years has agreed is archaic and confusing. And it doesn't take Congress out of the business of, it doesn't eliminate Congress's ability to look at any aspect of elections. It just says one or two people can't do it. It has to be a broader basis for objection, 20% of each House. I have two amendments to propose, and then I will withdraw. I want to outline what they are. One of them is in current law, the basis of an objection is the vote of one or more electors has not been regularly given. That's the law. That's the language from the ancient law. That's a term that is not very well defined and is confusing, and the scholars recommend that we change that to is unlawful or the product of unlawful coercion. It's merely a clarification of a term that really has no legal meaning. The second proposed amendment is even simpler, and that is that we're talking about where a court will have an opportunity to, in effect, referee these conflicts. And the current law, the current statute says such action shall be heard by a district court of 3 judges, convened, etc. One of the things we're trying to do with this statute is to clarify and restore the trust of the American people. And my suggestion is simply to add the phrase assigned on a random basis in order to prevent forum shopping by either party. It's impossible to predict. As the Republican leader pointed out, Democrats in the past have gone through this process of objecting, 1 or 2 objections here or there, and as the senator from Texas points out, a Democratic senator joined so that we had this process. So I think that assigned on a random basis rather than a kind of opportunity for forum shopping would again be a technical change, but which would increase the public confidence in the result that there wasn't gamesmanship going on in trying to select which judges should hear the appeal. So having made those 2 proposed amendments, I hereby withdraw them, reserving the right to bring them forward in a future consideration of this matter. I also want to compliment the chair and the ranking member for the amazing work that they've done on this bill, as well as the bipartisan group who recognized a danger to our democracy from an archaic, confusing, and abstract law, and to improve it, not to radically change it, but to improve it so that it meets the needs of the 21st century and will apply to both parties, any candidate in the future. That's what this bill is all about. Thank you, Madam Chair.
Thank you, Senator King. As well said as the independent senator could say. I think that's a really important thing to note, that we don't know who's going to win elections in the future, but both Democrats and Republicans felt it was important to take a